Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Today we're talking about how to get off the sex offender registry in the United States. This is a complex legal process, not a simple form you fill out, and this video is for informational purposes only. It is not legal advice. The single most important thing to understand is that there is no one federal system for removal. It is almost entirely governed by state law. What works in one state will not work in another. The first step is determining if you are even eligible for removal. This depends on several key factors. First, the nature of your original offense. States use a tier system, often tier 1, 2, and 3, based on the severity of the crime. People convicted of the most serious offenses, often classified as tier 3, may be required to register for life with no possibility of removal. Those in lower tiers often have a path to petition for removal after a specific period. Second, there is a mandatory waiting period. This is the amount of time you must have been in the community after your release from incarceration and successfully completed all parole or probation. This period is typically 10, 15, or 25 years, depending on your state and your offense tier. Third, you must have a perfect record of compliance during that entire waiting period. This means you never failed to register on time, never failed to update your address or employment, and followed every single rule to the letter. Fourth, you cannot have been convicted of any new crimes, especially not any felonies or any offense of a violent or sexual nature. If you meet these initial eligibility requirements, the process begins with filing a formal petition with the court in the county where you live. This is a legal document asking a judge to order your removal from the registry. You can't just send a letter, it has to be a specific legal motion. Once filed, the district attorney's office will be notified, and they will almost always oppose your petition. They will argue to the judge that you remain a danger to the community. A hearing will be scheduled where you, through your attorney, must prove to the judge by clear and convincing evidence that you are no longer a public safety risk. This is a very high legal standard to meet. You will need to present evidence such as a recent psychosexual evaluation from a qualified expert stating you have a low risk of re-offending, proof of steady employment and housing, letters of support from family and community members, and evidence of successful completion of any required treatment programs. This brings us to the most critical point. You absolutely need an experienced attorney who specializes in this specific area of law. This is not a do-it-yourself project. The laws are incredibly complicated, the process is adversarial, and a mistake can result in your petition being denied, forcing you to wait years before you can try again. An attorney knows the local judges, the prosecutors, and the exact evidence needed to build a winning case. To recap, getting off the registry is a long and difficult legal battle that is only possible for some individuals in some states after a long waiting period with perfect compliance. It requires a formal court petition and proving to a judge you are not a risk, a process that is nearly impossible without a skilled lawyer. Thank you for watching. If you found this information helpful in understanding this complex topic, please consider hitting the like button and subscribing to our channel for more content on navigating the justice system. Click that notification bell so you don't miss our future videos.